So we have already come across coercion, misrepresentation. The other one is fraud. Fraud exists when it is shown that a false representation had been made knowingly or without belief in its truth, or recklessly, not caring whether it's true or false. The maker intends the party to act upon it. In such cases you call it fraud. Or when there is a concealment of a material fact, or there is a partial statement of a fact in such a manner that withholding what is not stated makes which is stated false. In such cases we say it is a fraud. Essential features, elements of a fraud is there must be a representation or an assertion, and it must be false. In case of Peak versus Goodney, you could find the prospectus of a company did not refer to the existence of a document disclosing liability. Normally a prospectus is bound to disclose all the details regarding a company, but wherein a liability or the debt were not disclosed, this gave an impression that the company was prosperous and the other party bought the shares. But held non-disclosure amount to fraud, and anyone who purchased the shares on the faith of the prospectus could avoid the contract, because the material fact that the company had liabilities or debt were concealed. The second element is the representation must relate to a material fact which exists now or existed in the past. Example, the perfume is as good as that of X. This is a statement of opinion. This is not a concealment of or a fact. The perfume has much fragrance in them as that of a X. This we could say as a statement of fact. The perfume is the best available in the market for the price. This is basically, or it is just a puffing statement. A, while negotiating with B for sale of certain goods, tells him that the goods cost him 2,000. This is a material fact. But if we state that the goods are worth 2,000, this is basically or just an opinion about the good. Third one is the representation must have been made before the conclusion of the contract with the intention of inducing the other party to act upon it. That is, within a period of time before the contract is closed, inducing one party to enter into a contract concealing the material fact, you call it as a fraud. The representation or a statement must have been made with the knowledge of its falsity or without belief in its truth or recklessness, not caring whether it is true or false. The other party must have been induced to act upon the representation, or when you force one party to enter into a contract knowing it is wrong. Case of Smith versus Chadwick, we could find bought shares in a company on the fate of a prospectus which contained an untrue statement that 1B was a director of a company. A had never heard of B, and therefore a statement was immaterial from the point of view and A's claim for damages. That is, even if the prospectus of the company had misspelled that A is a director, even though B was not a director nor A knows B, in such circumstances we could say he is not liable for the charges. The other party must have relied upon the representation and must have been deceased. The other party acting on the representation or assertion must have subsequently suffered some loss. That is, there must be some financial loss which is incurred. Only in such circumstances we say fraud is happening. Common rule is there is no fraud without damage. That is, there must be damage which should have happened to any of the parties. Fraud without damage or damage without fraud does not give rise to a action on deceit.